Good morning, ladies and gentlemen, across our various platforms. We are streaming live on LinkedIn, Facebook, and on YouTube this morning, and we'll be discussing the Labour Law Amendment Bill, which we have dubbed the Great Labour Law Reboot. This is a second discussion in the series. We had one last year during March as well when the bill was first announced, and it deals with various amendments across the 5 major labour statutes, which we'll be unpacking today. I'm very honored and privileged to be joined by 3 of the leading legal minds in the labor and employment law here in South Africa. Mr. Jean-Ray Kruger, our national manager here at CEO, Consolidated Employers Organization, Mr. Daniel van der Merwe, our national collective bargaining coordinator, and Mr. Zwelakhe Twala, who is our senior dispute resolution official in Gauteng. We've got some very sharp minds, so please pick on them. We are opening this platform up for discussion and comments for all the employers, business owners, and people in the audience at large over here across the platforms. If you do have any comments or questions, please pop them through live on the chat. We will pop them through on the screen over here that we can have an engaging session. And without further ado, I just want to do a quick introduction just to let everyone know why we are talking about this. And then I'm just going to hand over to Mr. Daniel van der Merwe just to give a bit of background as to the public comment section as well. So, ladies and gentlemen, this isn't just a minor amendment exercise. It's a structural reform across the 5 major labor statutes in South Africa. The theme that we've picked up is the modernization of these laws, the enforcement being tightened, and as well as all of this being aligned with jurisprudence and case law moving forward. So a lot of the things we'll be discussing have been developed through the Labor Court and Labor Appeal Court, from the parental leave changes to basic conditions of employment, the Labor Relations Act, Employment Equity Act, and so forth. So the question isn't what has changed, but where is the risk shifting? And with that, Daniel, I don't know if you just want to give a few words as to the comments and how it will work. Thank you.
Okay, so thank you, Carl. Morning, everyone. Yeah, like you rightly said, we initially spoke about this about a year ago upon that NEDLAC report being published. And, this has kind of reached the stage now where it's, obviously the Department of Labor is looking to put this into law. And this is where the public comment process is coming in, and I think it's one of those things that we look at it in hindsight and go, shucks, we should have maybe contributed more, participated a bit more, and suddenly the law is upon us kind of thing. But what's so important about the amendment bills that have been published now is that they are open to public comment, so it's very important that all the employers out there, yes, the document is a bit long. Yes, the document is seemingly a bit complicated at parts. But we really, really encourage you to take some time, read through the document, listen to this session. If there's any comments that you have on the proposed amendments, or some of the times there's insertions into the bills as well in terms of new sections, we really encourage you to provide your feedback and your input, because as you rightly say, this is a modernization. It's a moving of the law to kind of adapt with the times, So it's so important that the more public comment you get, or the more participation you get, it obviously shapes the law, or shapes what's going to be, in front of us for the future, and reflects it a lot more from people's point of view as well. So even during this session, as we go along, I know you mentioned the comment section. If any employers, any person wishes to put a comment in the comment section regarding one of the points we're talking about, please, by all means, put it in there. We welcome feedback. We welcome input. It's something that will obviously shape our direction and our thoughts in terms of the commentary that we'll be giving. So just very quickly to wrap up, the commentary is due by the 28th of March, and we will be sending something out to members. We've already sent out the bill to members, but just giving a bit of a bigger breakdown or a deeper extrapolation of what the bills are saying, and inviting comment as well. So when that comes out, please, 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 we ask for participation and input there as well.
Thank you, Daniel. Yeah, this is 100% a chance for the public at large to reshape the labor law, to give their comments and feedback. And here at CEO, being the voice for employers, we are your voice moving forward with that. So we want to put those comments forward to the department and try and reshape these to the benefit of all parties involved. All right, ladies and gentlemen, to kick off a bit of the questions for our expert panel today. So at a high level, this amendment bill is a modernization exercise, in my humble opinion. But would you say it's more of a significant shift in how labor law will be enforced in South Africa? Chandra, I don't know. What are your thoughts so far?
Yeah, look, that's every time they amend, that's the question. How is it practically going to play out? How's it going to be applied? I think this is a modernization. It is bringing things a little bit together, trying to fix the gaps or fill the gaps that previous legislation had there. How it's going to play out, I wonder. I do believe, we are going to give comments on it, but I believe in the current structure, most of it is going to be enacted. So yeah, I'm sure there will be quite a shift. We'll delve into the more specifics, I believe, a little bit later during today's session, but it is something that needs to be taken note of. If you're going to be on the wrong side of the new legislation, you're going to be in trouble. So there will be a very clear shift, and we'll advise not just our members, but all employers to be aware of the changes and to apply the changes duly internally.
In terms of case law, and just a thought, a lot of all these amendments come from how the courts have been handling these, disputes moving forward, and the law is now catching up with what the jurisprudence has now dictated. Do you think it's a bit of a cleanup exercise, Genre?
Yeah, definitely. I think the courts have done quite well in identifying, as I said, these gaps, and now legislature, although very slowly, though, I know it's an odd. We were literally talking a year ago, or plus minus, like somewhere during 2025 about this, and only now we get to the legislation. So slowly but surely, but yeah, they're filling up the gaps. But the courts will keep on. That's the court's job, to keep on testing it, and people in our profession and in our situations, we need to keep pushing the boundaries anyway, as far as we can. We obviously, from an employer's perspective, and as well as organized labor. So we constantly, that's the nice thing about how it is set up in South Africa. You can always challenge it, and then legislature will have to catch up at some point.
100% agree. Thanks, Andre. All right, ladies and gentlemen, I want to start going through the different statutes. So we'll start off with the Basic Conditions of Employment Act. The bill formalizes the availability to work and requires guaranteed hours, cancellation pay, and limits secondary employment restrictions. So, Zweli, I'm going to pass this one on to you. I'm saving all the compliance questions for our head of collective bargaining over here. But, Zweli, are on-call and zero-hour contracts effectively being redefined? And what should employers urgently change in their contracts moving forward?
Hi, Carl. Thanks for the platform. I definitely think they are being redefined. I mean, if we look at the work environment post the COVID era, we are seeing a pickup in market trend where the employment relationships are more nomad-based. So you're getting a lot of remote workers and a lot of workers being available digitally and even internationally. And I think, like Andre's point has indicated, that our legislature needs to constantly keep up. Unfortunately, the labor law field itself, based on the employer-employee relationship, is so robust that we're seeing continuous changes within that work environment. So I think to also recognize that these type of employment relationships exist is an imperative and progressive attempt by the legislature to keep itself aligned with those changes. And if we look at also how they're trying to regulate those changes, it's important, managing or maintaining some sort of statutory obligation whereby, on-call workers are given reasonable notices for when they're expected to work, and also when those terminations come in. So it regulates those relationships a bit better. More so if we're looking at last-minute cancellation, who should bear the financial implications of a last-minute cancellation, where the employee's perspective is that, well, I've had to now avail myself for this. I was expecting to work for a certain amount of hours, and now the employer has cancelled at last minute. So there's definitely a balancing effort that's being made as we see through the proposed amendment in that regard.
Thank you. This is why I have you on the panel. All right. Zweli, I have a follow-up for you, just with regards to that. So if you could just tell the employers now in the audience across the platforms over, what would the practical risks be that they are facing pending these kinds of amendments?
I think the evident risk that I've been able to identify is that employers are facing the risk whereby they put themselves in breach of certain agreements or certain obligations on their end, and the financial implication thereof, where now there's an expectation that if you make a last-minute cancellation, you'll be expected to at least pay the employee for that last-minute cancellation. So I definitely think from an operational perspective, there will be some sort of financial liability. And from a CCMA perspective, we'll likely now see an increase in referrals specifically to Section 73A cases, where the basis of that case is essentially that I was essentially entitled to the hours per the instruction given to avail myself of this call. And obviously now the defense of no work, no pay will certainly be minimized in that regard. So I think for employers, it's important for them to take note that from an operational perspective, they need to plan accordingly in time. And also if they make those last-minute on-call cancellations, that there will be some sort of financial implications that may then lead to further disputes at the CCMA. We see a trend where commissioners are finding in favor of these employees employed in this sort of contracts.
Yeah, actually, as you're saying now, my mind is going to demand-based industry specifically. So I'm thinking of how it's going to affect retail, hospitality, security, and the increase in disputes that are going to be referred to those forums specifically.
Correct.
Yeah. All right, I'm going to move on to severance. This is a bit of a contentious issue. Daniel, and I'm going to ask you regarding this, because I think, a lot of these matters result to, from the retrenchments and all of that. But the bill now proposes severance being doubled, but only prospectively, not retrospectively. So with severance pay increasing to 2 weeks per year, how does this materially change the retrenchment strategy for employers?
Yeah, thanks, Carl. So I think the important word that you mentioned there is prospectively. I think there was initially a concern in terms of understanding this whole 2-week thing, and especially if you've got someone that's been in employment for a very long time, you think, well, suddenly if this ever goes the way of a retrenchment, I've suddenly doubled that severance bill in that perspective. But obviously going forward, this is what will be implemented. I think, it's obviously come from the basis of looking for social protection in terms of the no-fault dismissal. Obviously the employee is the one that's then going to be on the back end of it as a result. But my mind initially went to, when reading this passage, was in as much as it offers that social protection to employees in that scenario, when we look at retrenchments or operational or dismissals for operational requirements, they generally center around some kind of financial difficulty that the employer is facing. Not always, but generally. So my mind initially went to, but if the idea of restructuring for financial reasons, whatever the case is to be in a better financial position, by now having to pay severance pay at 2 weeks per year of service, it's making that financial burden ever more. So if you take a small employer, for instance, who's now suddenly facing this difficulty where they have to proceed with the retrenchments, but now the financial burden involved in terms of those retrenchments is increased, for me, it seems like the possibility of that employer then recovering in the long run is now suddenly facing a bit more of an uphill battle, as opposed to if it was in just the traditional 1 week for every year of service. So obviously, meaning that it'll be prospectively, it will take a few years for this to have some kind of impact or notable financial impact going forward. But I mean, as we know as well, time flies quite quickly. 10 years from now, suddenly that could have quite a big impact. So yeah, from a small employer point of view, I think that's where my concern comes into it, especially in terms of looking at longevity and sustainability of small employers in such scenarios.
Do you think it'll discourage operational restructuring? So, in the long run now, an employer will have to weigh up the costs of not just the retrenchment to save the business, but now whether they can actually afford to retrench to save the business.
Yes and no. I think, retrenchments are, like we say, it's a no fault in the sense of it's an action of last resort. And if it truly is an action of last resort, I don't think it will really circumvent or stop employers from proceeding with that route, but it might just take obviously a lot more thought or a lot more consideration of all the factors involved before maybe embarking on that as a last resort measure. So for instance, I'm just thinking a lot of collective agreements as well obviously provide for short time, just something off the top of my head. Those kinds of things might be implemented a lot more prior to retrenchments maybe being considered, for instance, but then that obviously has a detrimental effect as well.
Yeah, just Cole, if I can jump in there, I wonder, obviously we know why it's been done. It's being done to alleviate the stress and on the employee itself. I'm just so afraid of adverse effects of certain things. So instead of retrenching 5, I might now have to retrench 6 just to be able to foot the severance bill. So I'm just thinking practically how it turns out. So to be seen, but yeah, I agree with Daniel there.
It's an interesting time because now there's so much more thought that needs to go into these financial decisions, the feasibility of it moving forward from a business perspective. It's not just retrench to save the business and to keep the rest of the staff. It's now how many staff do I actually need to retrench to fit the bill for the severance that's also now helping the employee. So it's an interesting trade-off over there. But one of my thoughts that my mind goes to is fixed-term contracts. So Daniel, do you think that there'll be an increase in the use of fixed-term contracts to sort of alleviate this, specifically, in industries such as construction, engineering, and so forth? What are your thoughts?
I don't think so necessarily, because I think when it comes to fixed term contracts as well, the regulations there are so clear, and it's developed to such a point in recent times as well that employees are so well protected there as well that I don't think it will necessarily have an overflow in that. And I mean, especially if we talk about an industry like construction or engineering or things like that, those generally are very much project based or site specific, project specific. That I don't think it would necessarily open the door for that. I think it's just one of those things that we're trying to predict the future right now, where, in the sense of this will only come into play in a few years' time from a practical perspective. So yeah, it's a tricky one, but I don't think necessarily the fixed term, because that in itself also has certain protections, obviously with certain timeframes involved where the employee's been working. So I don't think necessarily it would.
Yeah, and employees obviously also entitled to severance if they're over, I believe it's 2 years of fixed term contract, 100%. Okay, moving on, ladies and gentlemen.
Sorry,
yes,
Carl,
no, really,
before
yes.
we move on, I think maybe another point of consideration would be, there's obviously the exception to when an employee will be entitled to severance pay. Would we now be seeing more employers exercising that right to try and actively secure alternative employment because on their balance sheet they really can't afford it? Or will we certainly be seeing a continued trend of retrenchment where one company takes on an initial retrenchment process? However, the implications of it on their balance sheet has now become so dire that they can't recover, and it leads to further and further more retrenchment processes, and possibly even forcing companies into liquidation. So like Daniel was saying, is that obviously we're taking a future perspective, but these are certainly the unintended consequences that we may start seeing within the market.
That's a very good point. I hope for employers' sake, to try to fit the bill a bit better, that they do try to secure alternative employment and show and record those reasonable steps, because at the end of the day, to prove that, you need to show what steps you've taken. It's not just a case of, please apply here and see what happens. They need to take those active steps and to be able to prove it at the CCMA or when the dispute is actually referred. So thanks for that, Sorry. All right. Ladies and gentlemen, we're going to be moving on to a topic we covered now in February, also during one of our live stream events, specifically on the parental leave policies being changed. The Labour Law Amendment Bill now deals with that a bit more in detail and gives a bit more clarity on the UIF structure and how that will be moving forward. So, Chandra, as the designated parent in the room over here, the virtual room over here, I really am interested in hearing your thoughts. So maternity, parental, and adoption, as well as commissioning leave, are now being consolidated into a shared parental regime. For the viewers who were not part of our live stream in February, you can go find it on our Facebook, LinkedIn, and on our YouTube over there. It is still available to view if you're interested in hearing about that in depth. So we just want to cover one of the or two of the points there again. But Genre, does the new consolidated parental leave regime simplify compliance or create new operational risks for employers moving forward? What are your thoughts?
Yeah, look, I think we covered it extensively in our previous live event in the fact that, they are trying to move to equality, and also something very much directed by the courts. So a good thing in essence. I think I was very outspoken about the traditional family setups. I don't know how much and how quickly that will change. But from a operational situation, how to regulate it, especially if well, in most instances, couples aren't, or married couples, or whatever couples, parental couples, don't necessarily work for the same employer. So regulating that and ensuring that, and I will get into the UIF as well, but ensuring compliance and that people don't misuse it is going to be a big issue operationally. Now, I can tell you, as I said in the previous one, I have seen some policies being set out for certain employers. They've already rolled out these policies in abeyance of the Act change. But yeah, they're requiring spouses to submit affidavits and proof of their leave submissions before they approve leave, in the normal sense. So I think operationally it is going to be a bit of a burden to make sure that it is being done and is being used correctly and it's not being abused. And very much the same with the UIF structure as well. But it was probably always coming, as the world grows and as we modernize society even more and more, these type of things are going to come up. The original parental roles are no longer what it was 10 years, 20 years ago. You do have situations where either parent could be taking care of the child. So operationally, it is going to be a bit of a burden, but if you have your policies and your checks in place, it's just, again, it's something that needs to be known and you need to regulate it accordingly. And once you're in that groove, I think, you'll be able to implement it quite easily. How the other structures are going to ensure compliance, I'll leave that to the state to sort out. I only care about the employer side at this point and how we can make sure that our members are compliant.
An interesting talking point, John, is a question that I was asked a couple of weeks back, and my thoughts on it for employers. So there are certain businesses and companies where the employers give the indulgence and the benefit to the, traditionally the mother of the child, where they can go on maternity leave and it's paid maternity leave. Now bringing in the second parent on an equal footing, how do employers go about that? Do they need to afford that benefit across the board for paid parental leave to both parties? Or what if an employer can't afford? So let's say both parents are now working for the same company. How do they go about changing those policies? Can they do it unilaterally?
Yeah, look, consultation, obviously, and it also might depends, is it merely a policy that has leniency, or is at discretion, or is it a term and condition of employment? From the bat, if what's good for the geese is good for the gander, so you cannot not extend that benefit to the other party as well. Look, if both are employed by one employer, great. I mean, your liability still remains the 4 months, 10 days, as it always would have been. The other side of the coin is now where you would have generally, I must say, budgeted for female employees, and the fact that they would be on maternity leave. Now you have to extend that equation to the male employees as well. So in practicality, you would probably lose two. So let's say the wife or the mother takes 2 months. So you would only lose 2 months basically, or have to pay 2 months, and then that 2 months will go to the husband side. So it should equal out, but I think where your essence is now, your problem financially is going to come, is where one of the parents, they're not working. So the mother's not working, and now all of a sudden you have a 4 month possible liability or possible benefit payment to a husband. So it might depend. I think it should equal itself out, except for in situations where only one parent is working, where you would have traditionally only had to budget for female employees. You will now have to budget for the complete workforce, basically.
Thank you for that, Chandra. Just one last question on this before we move on. And Daniel, I'm going to be picking your brain on the compliance in the following question. But Chandra, when it comes to the implementation of this, so a lot of companies now, employers are scrambling to change their policies and all of that. How is it currently standing? And I just want to give clarity to the employer. What should they currently do with regards to the male parent or the other parent now claiming? What is their limitation to claiming the UIF at the moment?
Yeah, well, the problem is the UIF Act hasn't changed yet, and therefore that benefit isn't available. So, yeah, how should you deal with it? Look, currently the status quo remains. The Act has not yet changed, but we would advise employers to move quickly and adapt. The UIF, unfortunately, isn't there, so I don't really know practically where the father of the child would, if you don't have that full benefit pay, would you really be in a position to be able to take off 2 months without any type of benefit, either in from your employer side or from UIF? So currently that benefit doesn't stand, and you cannot claim, currently you cannot claim UIF as the father. So that's where it currently stands from a benefit perspective.
Thank you for that, Chandra. All right, ladies and gentlemen, moving on to compliance under the BCEA. So stronger compliance orders, security requirements, union presence during inspections, and increased fines. The enforcement provisions are clearly strengthened. And Daniel, to you and your department here, are compliance orders and inspections now a higher litigation risk than before? And what are your thoughts on the security that's now being required from employers?
Thanks, Cole. Yes, so this one right up my alley. And quite frankly, whenever there's issues regarding compliance orders, whether it come from the BCEA or the DOL in terms of inspectors or even bargaining councils and from the agents, something I'm very passionate about, because it's one of those areas where if an employer is ill-equipped to deal with the compliance order or deal with the content of the compliance orders, it can really perpetuate a situation that turns out badly for an employer. So, when I initially read the proposed amendments, for instance, the new addition of the presence of the trade union during a labor inspection, it's first importantly to put that in its context, or in the caveat that's there. That's obviously in the frame of Section 14 of the LRA, so in the sense of where there is actually trade union representatives. But my initial thoughts regarding that were, in as much as I don't necessarily see a problem with that, I think for the sake of fairness, where there is a trade union presence in the workplace and the labor inspector is now compelled to include them in this process, there should be a reciprocating duty upon that labor inspector to also reach out to the employer and see if there is a registered employers organization involved. I think as an employer, a labor inspection, whether proactive or reactive, is something that is fairly daunting. It's not something that happens every day. It's something that if you're not well versed with the law, it can seem very intimidating. And I think it's also something that if you now got the registered trade union involved as well, I think it's a potential situation that can spiral, in the sense of what might have been a small issue, and where there might have been small, I don't like using the word small, but small non-compliance, if we can call it that, suddenly perpetuates and becomes this really big thing. So that's my initial thoughts. And then when you further that on in terms of the proposed amendments to Section 69, where employers then have the right to refer compliance orders to the CCMA for adjudication, there is this new insertion there regarding security that must be provided. Now, upon just a very plain reading of the proposed wording of that insertion, it says that employers must provide security when they want to refer the compliance order to the CCMA. However, when you read through the explanation regarding that particular clause, we start seeing that it merely is a way to suspend the compliance order. But I don't necessarily agree with that, because if one reads the wording in its plain context, it's a must. It's not something I can or I can't. It says you must. So, and just this is a topic that I can talk about for hours. I think everyone on the platform knows that quite well. But I think the really deep concern that I have regarding this proposed amendment is the fact that when compliance orders are issued, and with the greatest of respect to the DOL, they're very often, a lot of the times, nowhere near reflective of what the actual non-compliance is in that particular scenario. And what I mean by that is, often there's an inspection proactive or reactive where there is non-compliance found. It might just be an issue regarding payment of overtime, whatever the case might be, and there might be a small amount that's due, owing, and payable. But what happens in most scenarios is that inspector will then take these 2 or 3 employees and see there's 50 employees in the company, and suddenly apply that as a blanket to the entire company. And that employer is then suddenly sitting with a compliance order that should have been a few $1,000, but is now sitting at a few $100,000. And the difficulty with that as well is you've got 14 days within which to refer it to the CCMA. And what we do as CEO, and I know a lot of the officials, we try and engage the inspector and say, listen, there's a blatant error here, there's a calculation error, or the employer has actually complied, here's the proof kind of thing. But you don't get any response, you don't get any kind of interaction, and the matter ends up sitting at the CCMA anyway. So, that for me is really, really concerning in terms of what they're trying to do with this particular amendment, especially when you're sitting with a scenario where you've got a small employer, there's hundreds of thousands of rand compliance order sitting there, and now suddenly you need to furnish security for and let's be frank, a lot of those times when those matters are referred to the CCMA, the DOEL doesn't even rock up for those matters. I've been in a few where they just don't rock up. So as the employer, you're on the back foot, and it almost feels, I might say something quite controversial, but it almost feels that this particular amendment has empowered the labor inspectors to become judge, jury, and executioner all in one. And it in effect takes away the recourse that's provided by 69.5 or the current 69.5 that's in the basic conditions. So as you can hear, quite passionate about this one, strongly against the proposed amendment, precisely because a compliance order on the face of it is not definitive proof of non-compliance, which is precisely why it has to go through an arbitration process or a process of it being approved before it can be executed upon.
Yeah, so I find from my experience, dealing with these kinds of cases at the CCMA, you get to the CCMA and specifically with the non-compliance, the compliance order is inflated, as you said correctly. So the 3 employees that it's actually applicable is now, it's just copied and pasted across the board, where the employer's part was the employee wasn't even consulted in the process. It was an employee asking how much they earn. They've maybe inflated that amount. So that amount's been times by a 6-day work week and not a 5-day work week. And all of a sudden you're sitting with a compliance order for a couple of 100,000. And I just wanted to ask if you have any ideas on how the security would work. So just for clarity for the employers in the audience, is the security only needed when the employer challenges the compliance order and refers it themselves? And the second part to my question is, what would that security look like practically in terms of an amount? Is it a percentage of the compliance order, or how would that work?
Yeah, so thanks. So it's obviously it comes into play when the employer challenges it and refers it to the CCMA for adjudication. The current process that we follow is obviously within the 14 days referred to the CCMA, and then it gets dealt with there. And then, the wording of the amendment is such that it says equivalent to the value of the compliance order. And that for me is the big red flag that's going off to say that, again, like we talk about, it's overinflated. Yes, there might be some form of non-compliance, but nowhere near the extent of the value of what's on a compliance order. So when we talk about security equivalent to the value, that for me it's very concerning. It really is very concerning, especially in the context of a small employer, who doesn't have necessarily the security of a few 100,000 rand. And I mean, we've seen some of these compliance orders go into the millions, purely because of, in one instance, an arithmetic error. So it is quite concerning.
Zweli, you're now handling these matters, on the fly as one of the senior officials. What's your experience on the ground at the CCMA and the Bargaining Council at the moment with this?
Thanks, Carl. I think Daniel touches on the sentiment that more often than not, when we are dealing with compliance order, and when we review them, the compliance order themselves, we find them more often than not to be defective, the calculations specifically. And the financial implication of that is already it puts the member under distress because they're already looking at a compliance order and they're finding that they are not even in a position to even meet or pay that compliance order. Some of them don't even know when and how the inspector communicated with them or had that inspection to begin with. So there's that. And then when you go to the CCMA, the frustration that we often get is that if our attempts to engage with the inspector were unsuccessful, we are now sitting with the commissioner and we don't even have the inspector there so that we can raise these concerns and actually get meaningful responses from them before we can even advise the member on which position they need to take on these matters. So this is only going to add on to that ongoing frustration. And I think it also inadvertently will take away more of the employer's ability to oppose such compliance orders, because ultimately now you're cutting them off the legs before they even exercise their right to oppose it, because the security implications on small businesses is unimaginable. So now if you already have that money in liquidity to pay for that security, it only adds to the frustrations that we have with compliance orders. So on the ground, that is the feedback that we often get from them. And by and large, a lot of the time, the compliance orders I've dealt with, you've been able to resolve them with an inspector that is proactive and engaging, because they simply take the concession that, one, it was based on incorrect information, and also two, maybe based on incorrect calculation. Now the question becomes to then have to pay security in order to demonstrate these issues before a commissioner. Does that really balance out the scales of social justice? Because I think to some certain extent, employers are also entitled to the scales being balanced in terms of exercising social justice, especially at the forums such as CCMAs.
No, I agree. And I mean, practically, how often do you see employers actually paying the whole compliance or the corrected compliance amount up front? We usually, you know, agree on an installment payment just to get to the point of the full compliance being met. So now to place that kind of pressure on employers up front before they even can challenge it almost cuts their legs off, as you correctly say. So my parting question on this topic, Daniel and Zweli, for you two gentlemen, what would your advice be for employers sitting in this kind of situation?
Can I go first? Look, I think when it comes to compliance orders, whether it be from the DOL or the relevant bargaining council as well, being proactive is always key. Don't wait for the 14 days to run out. Don't wait for the matter to be sitting at CCMA waiting to be confirmed by the commissioner. Proactivity is always key when it comes to compliance orders. Do your level best to engage the inspector. And obviously, if you're a member of CEO, get it to us as quickly as possible, so that we can, take that engagement further and try and get it, sorted out before it needs to go any further. The big issue that also pops up later on is you mentioned it in the opening of the section, fines that can be imposed as well. Once that matter sits at the CCMA, goes through that formal process, that's when the fines can be actually levied against that relevant employer. So if that formal process can be avoided just by merely resolving it because there's a simple error, whatever the case might be, please, by all means, follow that route and make sure that we receive that compliance order timelessly as well.
Correct. And I think additional sentiment from my side would be that the proactiveness shouldn't just start when there is a compliance order. The proactiveness should also start from an operational basis. So how you keep archive of your financial documents, your payrolls, documents, your contracts of employment, your proof of payments, taking that form of operational proactiveness within the organization may also curtail the need for inspectors to impose or try to issue these compliance orders. So I definitely think with what we are now seeing and the legislator shift towards, it puts a bigger obligation even on small companies that from the very onset of the establishment that they ensure that their documents are in order. And more often than not, that becomes your saving grace into avoiding these compliance disputes to begin with.
Thanks, Welly. Sorry, while you were busy talking, I see we received a question over here from LinkedIn or on LinkedIn. Kindly advise how security should be provided. Must the security be issued in the form of a bank letter, or would a letter from your attorney be sufficient, or your employer's organization? Daniel, I don't know if you want to take this one.
Yeah, good question, Gustav. I know Gustav, so good question. Good. I don't know, actually. The way it's worded at the moment is quite open-ended in the sense of how the security should be provided. And also when dealing with an organization or an institution like the CCMA, yeah, I think that it's going to be a seen as we go kind of basis, because I wouldn't be quite sure in the sense of that, to be honest with you.
I believe they'll win. Sorry, John, you want to jump in?
Yeah, look, thanks, Gustav, for the question. Firstly, employers should come come up in their droves to stop this, because it's ludicrous to start off with a security. But yeah, I believe it's going to be the same as providing security when there's a review application. You'll obviously have to either pay in by your attorney, or you'll have to justify if you cannot pay it. So I believe the principle will remain. But this is a change that I think we have to vehemently oppose. There's no way that you can expect this due to all the things that Daniel and Zweli have just put out. So, Gustav, get your employers ready. We have to fight that one.
Thank you for the question there. I believe there will be more clarity once the comments have closed for this, but this is why it's so important for employers to provide us with their comments so we can submit this to the department and stop these kinds of clauses from being implemented. I mean, as Jean correctly says, it is a bit ludicrous in its implementation. All right, ladies and gentlemen, moving on just for time's sake to the Labor Relations Act. So, Daniel, I know this one's going to go back to you more on the compliance side of things and obviously regarding the bargaining councils, but businesses with fewer than 50 employees and operating for less than 2 years may not automatically be bound to the extension of bargaining council agreements. So the limitation on extending bargaining council agreements to a certain new or small business, is this meaningful relief or largely symbolic?
Yeah, so initially when this one popped up as well, it came up in the NEDLAC proposals, and I can understand the idea and the rationale behind it. Obviously there's a new business in play. They want to get their foot in the market. They want to make a name, establish themselves, and obviously provide a future going forward. I think the concern naturally from a collective bargaining perspective is the fact that an agreement or a collective agreement, whatever shape or form that might be in wages, conditions of employment, whatever the case is to level the playing field. So whether there's an employer with 10 employees or 2,000 employees, the idea is to level the playing field so that, for instance, if we use building or civil engineering sector once more, when tendering, for instance, if you've got a new employer that now suddenly doesn't have to abide by the collective agreements that are in place, and they can tender accordingly, in terms of the competition and the way forward, and even the abuse that might follow from that in terms of employers just setting up a whole bunch of new companies, it's a concern for me. I think the legislation as it currently is sufficient in the sense that it says before a collective agreement can be extended to the industry or to non-parties, there must be sufficient or adequate exemption procedures in place for that relevant bargaining council. And I think that is the more appropriate route that should be followed. So even if you are a small business, there are bargaining councils that make provision for small businesses to be exempt from certain clauses of main agreements. That's the correct route to follow. I honestly think that from a compliance perspective and an abuse perspective, this would open that door immensely to that, and it would, in a lot of ways, undercut that collective bargaining process that happens when negotiating wages and things like that. So in terms of the rationale, yes, I understand it. The rationales may be good, but practicality wise or practically I've got my reservations.
Yeah, no, I'm just thinking, worst case scenario where there's non-compliance from employers, it's going to be very difficult to curb an employer's discretion in opening up a new business. I think if you look at the positive stats for certain industries and sectors, the surge of new businesses is going to be astounding. I mean, that's awesome for the industry, but then they're non-compliant with the collective agreements, which undermines that uniformity of the sector or the industry itself. And I mean, from what you're saying is I can pick up that, this might create an unfair competitive advantage for new businesses. And for the compliance purposes from the councils, how do they know whether a business is legitimately new or if it's the same employer just opening up smaller businesses, and then just sort of rotating the staff through? You can imagine the inspection or the investigation that goes on for that kind of abuse.
Exactly, yeah.
Yeah. Okay. No, great stuff. All right. What are your thoughts on the changes to essential services and minimum service determinations, with strikes becoming more regulated, or do you think they'll be less flexible?
I think I'm going to throw this one to someone else, if you don't mind, Carl.
Genre, so let me throw it to you.
Yeah, industrial action strikes. Will it lessen strikes? I think strikes are starting to fizzle out, or in my very unpopular opinion. I don't think it's financially viable for people to really strike anymore. Yeah, a little bit tighter. I don't really think it's. I don't know. I don't know if I'm maybe just not reading it correctly, but not too much hoo-ha for me actually there. I think it remains what it is. Maybe just a little bit better, more regulations, but that's about it from my side. I don't think there's much to chat about it unless you have something specific.
No, I think we pretty much covered it over the NEDLAC report as well. I don't think strikes are as popular as what they used to be, and I don't think they're as effective as they used to be, specifically in today's economy and how things are running in South Africa, what's going on in the world as well. Can employers afford it? Not so much, but the employees can't afford it even more, if I can say it like that. So no, thank you very much for your input there, Genre. Just a passing question. All right, Zweli, the Unemployment Insurance Act, my good sir. We're looking at a full redesign of the benefit structure, due to things like the parental leave coming in, and obviously all the amendments now that are also affecting other subsidiary applications of the statutes over there. So the shift for maternity benefits to a structured parental benefit framework. What practical challenges will HR and payrolls now face because of this? I know we did sort of cover it, so if you can maybe just sum it up for the employers, that'd be great.
Thanks, Carl. I think this would be one of those questions that I would like to defer to Joandra on the basis that I think it touches on the point that he already indicated earlier. I will provide commentary after, but I think just to give an overview of what our opinion is on this one. Joandra, would you be so kind to assist me?
No, so 100%. Let me just simplify it for the audience over here. So obviously, because of the parental structure that is now changing with the UIF benefits, and I know we did touch on it, just in simple, and I kind of just want to sum these points up for the employers, so when they do listen to this, recording, that they can just get the crux of the matter. But John, do you think that the shift to the new parental structure, the practical challenges that it imposes now on HR and payroll structures, do you think it simplifies the administration or now complicates it?
Yeah, it's again the situation about ensuring that it's not being misused. Who's going to regulate that? I don't know if anybody has tried to claim UIF. It's not the easiest. It's not the easiest process. And I mean, I've been actively involved, especially with a lot of our employees who claim and need to claim, and the comebacks and the this and the that. So I don't want to venture too much into how the U-filing system works. My wife is in payroll and she's quite well versed in it, but still, it's a struggle. So, how is that going to look? Doubling the burden, because as we said, it's going to bring extra burden internally for HR. But how is that burden going to look on the current UIF system? How's it going to look financially, and how are they going to ensure that it's not being misused? And again, where they originally only had to cater for the mothers, they now have to delve into the budget and also identify where am I going to get the money for this added liability. So I think a lot of headaches. It was going to come, and as I said, I mean, out of a equality perspective, it is correct, that it is being done like that. How will they prepare for it? How are they going to budget for it? And how are they going to deal with that influx? And ultimately, how are you going to ensure that it's not being misused? It's to be seen. I don't know. I don't want to, and it sounds like I'm, for a lack of a better slang word, I'm ragging on the department here. But and I have to give kudos. I was at Binnelandse Sake or Home Affairs the other day, and it went very smoothly. So maybe they are shaking things up, and some of the state departments are getting better. But I think there's going to be quite an administrative burden on them. So let's see. I don't know. As I said in the last live event, my wife's already made it very clear that I'll be working, so I won't have to go and test it.
Thank you, Jean-Ray, for that. No, so for our audience out there, for the employers and business owners out there, what are your thoughts on the current changes for all the parental leave? I would love to hear them and would love to submit them as the feedback as well. Jean-Ray, off screen before today's live stream, we did discuss the 13-week requirement for parents to be employed and contributing to the UIF for 13 weeks to be able to claim UIF. What are your thoughts on that? Do you think that is enough of a compliance or do you think that's going to create a bit of fairness concern?
There's always been regulations of how long you had to contribute for certain types of benefits and how long in between claims. So that's a general UIF thing. I think it is a sustainability thing. It was obviously one day thought out by an actuary and at least contribute so many payments before we can start making payments. So I don't really think there should be too much on it. There's always been timeframes linked to the UIF or to Unemployment Insurance Act. So I think it's not just the same. I can't really see it as discriminatory.
And just a parting thought on the claim limit per 12 months is one claim in 12 months. Do you think this affects the family planning scenario? I mean, whose responsibility would it be? The employees to know these things? Let's say you're planning to have 2 kids, maybe with multiple partners, I don't know. But do you think this impacts the way families would be structured moving forward?
I'd like to hope most people do family planning. So, yeah, you have to take it into consideration. I mean, it's like any insurance, it's if you certain insurances, if you don't claim, you get bonuses, or you cannot claim for the same thing twice, or it's regulatory. I think all aim to make sure that the actual the fund stays liquid and not insolvent. So yeah, it's normal regulations, I think, to make sure that the fund keeps on going. So yeah, I think general stuff there.
Thank you very much. All right, ladies and gentlemen, we are moving on to the back end of today's session. We will try to wrap it up within the hour. We want to actually create shorter sessions, just that are more impactful, that we can get to the point. But to wrap up today's session, we just want to touch on the National Minimum Wage Act, the EEA, and then just some general comments from our side over here. But Sweli, regarding the National Minimum Wage Act, so allowances and deferred payments are now clearly included in the minimum wage calculations. So I know from a practical point of view, handling these matters at the CCMA, there was always discrepancies with restaurants, where the tips were included in the national minimum wage calculation and the payments there. But which employers do you think will be most exposed now regarding the allowance and deferred payments? And do you think that this closes historic loopholes, or do you think it creates some more?
Hi, Carl. So my initial thoughts are that, like you're indicating, employers within the restaurant entertainment businesses will likely be the most affected. I don't want to touch on the employees that are already falling under certain bargaining councils, because bargaining councils have, through main collective agreements, tried to address these particular issues. But for contextualization of this particular issue, I think we need to shift our focus to those employees that are earning on the national minimum wage threshold, and ultimately what the implications are going to be for Section 73A disputes. My mind immediately can't move past that situation, where ultimately we're seeing that the threshold was a determining factor as to whether or not a dispute falls within the jurisdiction of the CCMA. But now that there's an inclusion of these allowances, will that push certain employees above that threshold? And would that now see that even though they are regarded as, vulnerable employees, will then now lead to jurisdictional issues being a point of contestation at the CCMA level? So I definitely do understand the rationale in trying to, have a more overview approach in trying to actually determine which specific monies can be included in terms of calculating this. But I think at this stage, one would need to, it'll be an ongoing engagement as to what would the practical implications of that be, and would it also be more feasible for employers in that regard. So at this stage, that is my commentary on that aspect.
Yeah, I think in essence, it actually makes it easier for employers to comply with the national minimum wage, especially with it being increased every year. I think it jumped about 7 point something % from last year, which, the standard of living is pretty expensive now, even for across all classes of earners. However, with this being included, it does lighten the burden for employers a bit to meet that threshold with allowances and deferred payments. So we might see a decrease in 73As on the technical aspect for people claiming. However, it also then has the benefit of helping employers to meet that, specifically where they're trying to get off the ground and trying to actually just, get the business going to help the lower the employment rate or the unemployment rate. Apologies. All right, ladies and gentlemen, employment equity. And I think this is one of the last topics we'll have before general comments over here. If you have any thoughts, please pop them through in the comments and we'll deal with them. Even if it is after the fact, we love to make these sessions engaging. We love to hear from the employers and the members in the audience. But sexual harassment referrals. So historically, sexual harassment was always dealt with under discrimination, which for me was a bit weird because I do see them as two different kinds of referrals. They're now being included at the CCMA. Do you think that this, and I'll open up to any of you if you have your thoughts, do you think it increases exposure for employers, or do you think that we'll see more internal disputes being resolved at the workplace through, counseling, through disciplinary action or grievances per se? What are your thoughts over there, gentlemen?
Okay, let me jump. Look, it's always been a contentious issue, and I mean, this is something that needs to be resolved quickly if there are those type of situations in the workplace. So one would hope that it is resolved internally quickly, and that those type of matters or those type of situations are removed from the employment environment very quickly and eradicated as a whole. The CCMA. Yeah, I don't really have further comment on it. I think they might deal with it as they see fit.
Yeah, I think if I can just come in there as well, just very briefly, is there's obviously a proposed amendment that the relevant bargaining council can deal with certain disputes as well, provided obviously there's accreditation or it's in a collective agreement. So that expansion is also there. So something to look out for as well.
Great. Zweli, any thoughts, or can we move on to the rapid fire to end off today's session?
I think my parting comment would be that it's likely for us to see an increase in these referrals. From an operational perspective, I mean, employers must always take note that the code of good practice that specifically is addressing issues of sexual harassment in the workplace. And then you read it with the Employment Equity Act, that there's already an obligation on employers to strictly regulate these issues internally, deal with them quickly. There's clear guidelines in terms of how the policy frameworks should be done. All that this implication will have is that it will place a bigger obligation, or let me say, there'll be more scrutiny on employers when the increase of such disputes are referred to the CCMO bargaining councils alike, conditioned to their accreditation. So definitely we likely see an upward trend in terms of disputes of this particular nature, and it will be interesting to see how the CCMAs and the bargainings deal with it in that regard.
100%, I agree with you completely. There's really, I think, as well from an employer perspective, we have the prevention, or the code of good practice for prevention and elimination of harassment in the workplace, which has, these guiding principles for employers and the vicarious liability that falls on them for sexual harassment disputes as well. So again, something to be proactive about and not reactive about in the workplace over there. And I mean, those guiding principles were effective from, I think, March 2022. Somewhere around there. So that is available for download as well as on our website and across our platforms. Ladies and gentlemen, so I'm going to conclude today's session just with a quick rapid fire. I do want to just quickly shoot through. So Daniel, I'm going to start with you. You're top left of my screen. So if you had to identify one provision that employers should comment on regarding these amendments, what would it be? Just quick, short.
Sure.
That's all we want to know.
I think it's a very easy one for me, the compliance order aspect.
The security.
Yeah.
100%. All right. Genre, your thoughts?
Yeah, no, definitely that one. There is no other term. We are going to comment on everything, but that is something from an employer's perspective. I cannot see the rationale I don't know what the point of that is, and unless we do it across the board, then please, so we can have a little bit of security by applicants as well, to at least secure, to secure employers' attendance at arbitration, stuff like that.
Level the playing field. Indeed, agreed. Swelly, your thoughts. One thing you comment on.
Thank you. I think it's important for us to have an effective voice on the issue of the proposed increase in severance payment. I think based on what we've already addressed here, I think our employers really need to take opportunity of this commentary period and actually, give us that more practical understanding as to how it will have operational implications on them. So I think it's one that should definitely not be minimized, because already it has such a huge impact on employers as a large. Granted, we're not disregarding the impact that it has on employees as well, but I definitely think it becomes an issue that legislature would really need to take a holistic understanding before they decide what the final implication of it or enforcement of it, should it then remain as part of the amended bill.
No, agreed, really. Thank you so much. All right, ladies and gentlemen, last question for today, and it is just one of clarity seeking and commentary, obviously, from your side, and then we'll just say goodbye for today's session on this lovely Friday. But ladies and gentlemen, to our panel, where do you think the greatest litigation risk will lie in these amendments? Daniel, you're up first.
I think it might not proliferate itself in terms of litigation as what we see, but one of the sections that's possibly going to be amended as well is the fact that Section 73A claims, Swelly mentioned it earlier, the bargaining councils would now be able to entertain those as well. And I think when you look at certain industries as well, that could create a proliferation of those kinds of disputes, especially because they can then sit at bargaining councils. So maybe not in the traditional sense of litigation, but I think that's where you could have a lot more dispute and representation happening at those forums.
Agreed. I see we do have a comment over here from LinkedIn. If we can just pop it up on the screen over there, and then if there are any parting comments from the rest of the gentlemen, we can then deal with that. So this is there should be a national register flagging employees or potential employees who abuse labor and employment protections. For example, I assisted on a case where a female employee used sexual harassment allegations against her direct manager whenever she was up for performance review. It was discovered that she used this tactic at 3 different employers. This is quite an interesting point. A national register for employees, almost, usually these registers are used for sexual offenders and so forth. But this is an interesting comment. What are your thoughts, gentlemen?
I think you're going to run into a poppy wall. Yeah, look, it wouldn't that be great in an ideal world? Because with the limitations of even doing, in Teresa, I can hear the frustration, to not even proper reference checks, because you're so limited to the information that you can share. Yeah, that would be great. Again, I think it's a very easy solution. If you, in any other system, if you waste the court's time or you have instituted frivolous claims, you bear the costs, and it's such a simple solution. And again, I don't want to go on a rant, but the CCMA complaining about their budget, caseload, all of that can be alleviated by a very simple point. Do not litigate or do not refer if you do not have a case, and pay the repercussions. Exactly here. If that is found out, if you have the evidence of 3 previous employers, or there are 3 previous awards of an individual, surely that person must pay the cost, not just for the employer, but for the CCMA. But the CCMA and our labor legislation refuses to do that, hence their perpetual circle of issues. Budgetary, caseload, and that's there's an easy solution.
I think that's up for debate for another hot topic, a controversial topic. But no, completely agree. I think that is an easy solution. We'll have to iron out our suggestions of how they could be implemented. But ladies and gentlemen, thank you so much for your comments, your engagement. That is unfortunately all we have time for today, but please stay tuned. We are going to be hosting more of these live sessions moving forward on various topics, and we'd love your feedback as well. If you have certain topics that you would like us to discuss live, ladies and gentlemen, please shoot them through. We'll vet and approve them, and then we'll take them from there. But I hope you have a wonderful Friday. Enjoy the weekend, ladies and gentlemen. Enjoy the sport that's on. And from our side, it's always a pleasure having you guys. Thank you for the engagement, and enjoy.
Thanks, everyone. Enjoy your Friday.
Cheers, bye.